Have you ever wondered about the intricacies of reasonable suspicion and the authority to search during traffic stops? Complexities abound, but today we journey through the fascinating world of case law to untangle these complexities, starting with the pivotal case of Johnson v. United States. Let's go back to the year 1996 when the Johnson v. United States case came to light. This case revolved around a frisk of a backseat passenger during a traffic stop. The question raised wasn't whether this passenger had been subjected to an unlawful search and seizure. The court ruled that the search was indeed unlawful, as the police did not have a reasonable suspicion to frisk the passenger. This case set a significant precedent in determining what constitutes a reasonable suspicion during traffic stops. Moving forward in time, we arrive at the 1999 case of Wyoming v. Houghton. This case extended the scope of search during traffic stops. The Supreme Court ruled that if a police officer has probable cause to search a car, they may also inspect passengers' belongings found in the car that are capable of concealing the object of the search. Fast forward to the year 2004, and we encounter the case of Hebel v. 6th Judicial District Court of Nevada. This case tackled the issue of identifying passengers during a traffic stop. The Supreme Court decided that a state can indeed require a suspect to disclose his name in the course of a brief stop. With these cases in mind, it becomes clear that the interpretation of reasonable suspicion and the authority to search during traffic stops has evolved over time. The Johnson v. United States case is particularly significant. It highlighted the importance of having a reasonable suspicion before conducting a frisk, setting a precedent for future cases. In summary, Johnson v. United States established the need for reasonable suspicion before a frisk. Wyoming v. Houghton then expanded the scope of search if there's probable cause, while Hebel v. 6th Judicial District Court of Nevada affirmed a state's right to require a suspect to disclose their name. These cases underscore the balance between law enforcement's duty to protect and an individual's right to privacy. They serve as a reminder that our legal system is a fluid entity, constantly evolving and adapting to address the ever-changing landscape of societal needs and rights. And as we continue to delve into the intricacies of law, we gain a deeper understanding of its impact on our daily lives. Following our discussion, you may be curious, when can the police ask for a passenger's ID during a traffic stop? Generally speaking, the passenger is not automatically considered a part of the stop. However, if the passenger chooses to insert themselves or interfere with the stop, the officer then has the authority to ask the passenger for their ID. By interfering with the stop, the passenger is now breaking the law. From a legal perspective, police can ask for a passenger's ID if they have reasonable suspicion that the passenger is involved in a crime. However, if the passenger is not interfering, they are generally not legally obligated to it unless they reside in a state with a stop and identify statute, as seen in the Hebel case. It's crucial to remember that these laws are not universally applied, but vary from state to state, and or if you are on federal land, such as a military installation, national park, forest, or wildlife refuge. So, knowing your local laws is essential. Understanding the conditions under which an officer can ask for a passenger's ID, the legal implications, and the rights of a passenger is vital in dealing with such situations. Knowledge is indeed power, and recognizing when and why police can request your ID is an integral part of understanding your rights during a traffic stop. Please remember, this is just an educational video and not legal advice. I'm a police trainer and not a lawyer. Follow the laws in your jurisdiction and your agency policies. Thanks, everybody. Please like, subscribe, and share.